There are so many intricate little things in the law of succession that you need to know and that you need to keep in the back of your mind when you're working with clients, that sort of thing is very important. In other words, if I can get you to that point where you see, okay, maybe I need to sit down and open the book and really study, that would be one of my goals for today. The other thing is, if I can get you to realize that succession and wills and estates are not as boring as it sounds because you're working with dead people, then that would be something else that I would achieve today. And just to show you that it's not boring, I'd like to read from a case, from a will that actually appeared in court. Let me just see how many of you don't understand Afrikaans. Then I'll just translate for you. Because Mr. Schnettler wrote his will in Afrikaans. His bequests were, amongst other things, to mevrou Ina Stokes vir die mooi wat sy in my lewe was, R5,000. In other words, to this lady, for everything beautiful in his life, R5,000. Then to Mrs. Joyce Botha, wat my hart verower het in so 'n kort tyd, R5,000. So in other words, this lady managed to capture his heart. To Mrs. Krishna Schnettler, my skoonsister, wat vir my baie beteken het. So his sister-in-law, which meant a lot to him, also R5,000. And so it goes on and on and on to all the ladies in his life. And then in the end he said, begrafnisreëlings, by die roudiens in die kerk, die lied, to all the girls I've loved before. And by die sak van die kus, I did it my way. So it does get interesting. It's not always boring. So if you deal with wills, see the funny side, see the interesting side. If you cannot find something interesting, then let me give you the best advice ever. Find another job. Because if you are bored with what you are doing, you are not going to be able to give your clients the advice they need, and as I will show to you very soon, you are going to land yourself in hot water. If we can then start by looking at the drafting of the will, first of all, there is a serious amount of skill required when you draft a will. You cannot just be a total layman and think you can draft a will properly for a client. You do need the required knowledge of the law of succession, and as we go through today, you will see the things that you need in the back of your mind, which is part of this knowledge of the law of succession, so that you don't fall into a trap when you draft a will for a client. You also need a certain amount of practical knowledge. You need to be able to think practically what the provision that you are putting into a will is going to mean in the end. How is it going to work in practice? It's no use having it on paper, but in practice it cannot work. So you need to have that. You need to remember that your client has spent a lifetime amassing his estate. So he wants professional advice. He doesn't want to go and sit with somebody who does this for free, who does not have a clue what he's doing, because he has really spent time and effort on what he has in his estate. So it is important that you give him the correct advice. You need to be able to play devil's advocate, and that is very important. You have to say to your client, but why do you want to do this? Is this really your intention? Is this really what you want? And most importantly, you have to be able to say to him, but what if? What if this happens? What if that happens? So you need to think a little bit ahead and say to yourself, okay, the client hasn't provided for this scenario, so I need to ask him what will happen if the following facts appear. Now, why is that so important to play devil's advocate? Who can tell me? Why is that important? Come, any ideas? Why is it important?
Cause and effect. So anything they put down may have another meaning or may result in a certain set of circumstances at the time, which requires interpretation.
Correct. And what is that going to cause?
It's going to cause legal fees. You're going to get
It's going to cause legal fees. It's going to cause court applications. So there's a cost component. And what is that going to cause? Delays, you can cope with delays. Something much more important and much more serious. Loss for who?
For a client.
The client's dead. He's not going to care. Exactly. Because you are going to get somebody that we call the disappointed beneficiary. The disappointed beneficiary is that person in the background, the friend, the aunt, the uncle, the son, who thought, I'm going to inherit something, who knew he was in the will, and now you've made a mess of the will is invalid, so now he's no longer going to inherit. So who is he going to come after? You. You as the drafter of the will is going to be the person in trouble. You open yourself to a delictual claim if you are negligent in the drafting of that will. So it's very important to make sure that you know what your client wants and that you put exactly that onto that piece of paper, and then make sure that that piece of paper is actually a valid will. Let me show you an example. And this example is from an actual example that the parties came to me for advice, and there was nothing much I could say to them in the end. We had Mr. and Mrs. Steyn II. They were married in community of property. Mr. Steyn was an older gentleman. Mrs. Steyn, according to the family, your younger, typical gold digger, as they called her. So obviously he was the wealthy one and she didn't have a very big estate. Now part of Mr. Steyn's estate was a beach house that had been in his family for 3 generations. So it was quite important to his family. They each had 2 children from previous marriages. He had 2 daughters, she had 2 sons. And then the 2 of them went and they made a mutual will. Now here comes your first exam tip. Definitions are very, very, very important. You cannot apply the law of succession if you do not know your definitions. So what is a mutual will? Not everybody at once.
Both spouses do the will together. Jointly.
Okay, what you are explaining to me is a joint will. The lady's answer was, I'll ask you now, her answer was, it's when 2 spouses make a will together or jointly. That is the definition of a joint will. How does that differ from a mutual will?
They leave the estate to each other.
Exactly. So a mutual will is a joint will where they leave the estate to each other. And this is what they did in this case. They said, we leave the estate to the survivor of us. Then they said, the estate shall be shared equally by all 4 the children. Now remember, 2 from Mr. Steyn, 2 from Mrs. Steyn, upon the death of the survivor. The only other provisions they made in the will was for legacies. It stated that if Mr. Steyn died first, his 2 daughters will get 60,000 rand each. If Mrs. Steyn died first, then her 2 sons will get 60,000 rand each. Now that was quite an important provision in the end to try and establish intention. But now, does anybody see a problem with this will so far?
I don't think his children is going to be very happy if she didn't really bring much to the estate and they basically going to share.
They're going to share after she inherited it if he died first. But where does the problem lie?
The stepchildren are inheriting equally to his natural children.
That's correct, but according to the will, only after the survivor. So they were quite happy. She will have it for a number of years and then they will share.
She can change the estate. She can change. Well, she can't.
No, she can't because this is a fideicomissum. But what is the problem? What if? What if she refuses to inherit? What happens then? If the survivor repudiates, what happens then? And this is exactly what happened, because upon very good tax advice, she decided that it's going to be better for her not to accept the estate because it would have had huge tax implications. So she said, no, I'll step back. I'm not going to accept his half of the estate. Remember, they were married in community of property, so half belonged to her in any case. Now she said, I don't want the other half. What happens now? What concept is that provision where they stated, we leave it to the survivor. Upon the survivor's death, it goes to the children. What is that? See why definitions are important. Yes, it's a fideicomissum. So, what are the rules concerning a fideicomissum when you have the situation that the fiduciarius is either dead or disqualified or does not want to, repudiates, as in this case? What happens then? What do the rules to a fideicomissum state? The question that becomes relevant then is whether acceleration of benefits can take place to the fideikommissaries immediately. So the question here is, should acceleration take place? The will is clear. It says it goes to the survivor and then afterwards to the 4 children. So do you think the daughters were happy? No, of course not, because that meant they now have to share the entire estate, of which the beach house was a part, with the 2 stepsons. And in this particular case, it meant that they might have had to sell the beach house, which they were not happy about at all. And that is where the trouble started. That's where the fighting and the interpretation of this will started. Now, I cannot give you the solution. I don't know what happened in the end. I advised them that they could possibly argue in court, because of course they would have to go to court, that the intention of the testator from the legacies of 60,000 rand could possibly have been that his daughters should have preference. But whether they would have succeeded, I cannot tell you, because it's a question of interpretation. The point being, do you see how important it is to think, but what is going to happen if this is what we put in the will and something that we didn't think of happens? So you have to, as the drafter and as the client's advisor, you have to think of everything. Let's just
Ask you a question, sorry. One of the rules is that the testator should draw up the will. So why would we, as handling that, be responsible when...
There's no rule, and you are the professional, we are getting to that, advising him and drafting the will for him. We will get to that in a moment. Okay.
Sorry. I just want to ask, if the survivor, can you put it in your will that if the survivor repudiates the will, that it should go to someone else?
Yes, we will get to that as well. That is a direct substitution where you then say, if she doesn't or cannot or for whatever reason does not want to, it goes to so-and-so directly. Okay. That is one of the concepts that you use, and that is exactly why you have to ask that question, what if, so that you can put that extra provision into the will. Let's just quickly look at another example. And this is also from a factual scenario, and unfortunately, one sees this kind of provision in a lot of standard form wills. And a standard form is the bane of my existence. A standard form is the worst thing ever, but we'll get to that. Let's look at this example. I bequeath my entire estate to my spouse. Should she fail to survive me for a period of 30 days, I bequeath my estate as follows. The residue to my daughter. Now, there was already a problem because there was no provision with regard to the estate should that scenario take place, only as to the residue, which was already wrong, and that is a typical standard form problem. But let's leave it at that. To my daughter, subject to clause 5. Clause 5 says the award to my daughter has to be kept in trust for her. So what happened now? The spouse died 28 days before the testator. What is that if she survives me for a period of 30 days mean? Does it include if she dies before me, 30 days before me, or is it only if she lives for 30 days after me? What was the intention here? And remember, look at the provisions. It has a huge impact. If it was intended only if she lived after the testator died, it means that these provisions apply, which means the residue has to go into trust for the daughter. If it includes dying 30 days before him, it means she couldn't inherit, the will is ineffective, the estate is to devolve intestate, which means the daughter gets it immediately. So there's a huge discrepancy in what is put on the paper there. So again, you have to be very clear. There, if your intention is after me, then it should state, should my spouse die 30 days after me? Okay, so the interpretation problem there is quite heavy. Most of you would say, oh no, it's after me. But look at it. That's not what it says. So you have to be very careful.
But to survive somebody,
Is
you have to- that,
after the person?
how do you survive somebody if you've died before them?
Yeah.
Exactly. If you look at the intention, she didn't survive me. And she didn't survive me for 30 days. Look, if she had died 6 months before him, it wouldn't have been an issue. But here, it was 28 days. So she was in that 30-day period. Does that include that? Do you see the interpretation problem there? And you can argue this one, you can argue that way, and 50% of people will say to you after his death, and 50% will say before his death. And where do you go with that? So it means you have to go to court, and the court will have to tell you, okay, this is how we're going to interpret it. And again, costs. And what do you have when you have costs? You have, again, the disappointed beneficiary. So no provision was made for that scenario because nobody asked him, what happens if she dies before you? Nobody thought about that. So it is very important that you state that also. And this illustrates the responsibility that falls on the drafter. As we have seen, you don't want a court application, you don't want those costs. Because the drafter is going to be liable. The level of skill that is expected of the drafter is a very high level of skill. And the reason for that is because the Attorneys Act says that anybody may draft a will for a fee. Anybody. But that implies, and that is how the courts have applied it as well, that that person who drafts it should illustrate the same high level of skill as an attorney. So your duty and your responsibility as a drafter is actually quite high because you are expected to have that legal knowledge and to make sure that that will is valid and that the content can be applied. So the drafter has quite a responsibility on him, not only with regard to the content and the validity, but also in telling your client to update the will regularly. Now, a lot of people are going to say, oh, that's unfair. How can we be expected to tell the client? These days, it's easy. Electronic diary, send your client a letter, say to him, listen, it's time. If he comes and he updates his will, you have done what you were supposed to. If he doesn't, you have also done what you were supposed to. Let me illustrate with another example. And again, this comes from a practical example that landed up in front of 4 attorneys' firms and 3 advocates, and nobody could do anything. Mr. and Mrs. X the first, again married in community of property in 1965. What is the effect of their marriage in community of property? One estate, in other words, each owning half of the estate. They had no children. They made, again, a mutual will in 1967. In other words, what did the will say? They left the estate to each other. Mutual will. And then, a few years later, in 1975, they got divorced. And another few years later, in 1978, Mr. X married Mrs. X the second. Now, in this case, it would appear like he was the gold digger because he again married her in community of property, but at that stage he was factually insolvent, whereas she was quite a successful businesswoman. She had a successful clothing business and she was the wealthy one in the relationship. Also at that stage he was already sickly, and then 6 months later it was game over. He died. So what happens now? Who inherits his estate? The first wife, because he has a will that says it goes to the first wife. And what does she inherit? Half of the new wife's estate, because he was married in community of property, he had nothing, she was the wealthy one, so it's half of her estate. They went backwards and forwards. They, as I said, had 4 attorney firms. They had 3 advocates. They kept trying to find a solution, and there is no solution. Why? Because he forgot that he had a will made in 19 Futsak and never updated that will. Luckily, nobody whispered in Mrs. X II's ear, but hang on, there's a drafter somewhere there in the background that we can say, come, this is your fault. So I advised them that the only way to get past this was if Mrs. X I said, no, thank you, and what are the chances? No. Of course she's going to say, oh, I'm rich, great fun. Exactly. So it is your responsibility to tell your client, listen, at least every 5 years, better even every 2 years, because your circumstances change, people die, you get sick and tired of your cousin, you don't want to leave anything to your cousin anymore, whatever the case may be, that will needs to be updated. So it is quite a heavy burden on the drafter, but that is part of the drafter's job. And that goes together with the estate planning that a drafter has to do with his client. Of course, the drafter doesn't have to have knowledge of every single aspect. That is why you do have people like tax experts, like financial experts. So you can get people from other fields together and do proper estate planning for your client before you start drafting a will. We're going to see later on that when this comes into play, you can even set up a trust inter vivos for your client. So it's important to do that estate planning, but to get advice from other people. Of course, you're going to be expected to have the legal knowledge, and as I said earlier, also think practically. Think what is going to happen if you do a certain thing. Now, as I said, standard forms are the bane of my existence, because most of the problems that we see come because of standard forms. They can be useful, they can give you an idea of how to do it, but if you grab a standard form out of your drawer next to you when the client is sitting in front of you, make sure it actually conforms to your client's circumstances and that it can be applied to the client's circumstances.
I just want to ask a question in terms of what you just said previously. But let's say you get married again, and within the 3 months of getting married to your new spouse, you die. Is it true that you got a 3 months period to change your will? Yes. But after 3 months, then you don't change it, it becomes valid, and then it goes back to the first.
Remember, it's always valid. Don't get your terminology mixed up. The only thing that happens is if you die within the 3 months after the divorce, the previous spouse, who was now the beneficiary in the will, is considered to be predeceased. In other words, she cannot inherit. He or she cannot inherit. If, however, you do not change your will in that 3 month period, it is assumed that you intended that spouse to inherit. The legislature, when he put that provision into the Act, decided that 3 months is enough for you to think, oh, I've got a will, I've got to change it because I no longer want my ex to inherit. If you don't change it, then we'll assume that you wanted the ex to inherit. And then that provision, as it is, will be applied. Okay, it becomes ineffective. It doesn't become invalid. It's just, if the will, for example, said, I leave 50% of my estate to the then ex, to my wife or whatever, who's now later the ex, and 50% to my 2 children, then the 2 children will still inherit that 50% because that is what the will says, and the 50% that was supposed to go to the ex will fall into the residue of the estate because you can no longer give it to her. There's nobody to take it, so it falls into the residue of the estate, and that is why it is also important to say in your will, the residue of my estate goes to, and let's say the 2 children in that case. It is important. Often people think, I won't have a residue. But you never know. You never know if there's anything left. So it's important to say any residue will go to somebody.
Okay. What if scenario?
Exactly.
And that's saving us against challenging for delict against what our preparations are, because we've covered what ifs.
Yes.
Okay.
Yes. Exactly.
So the term where we've got that 3 month period here, what is that called? What is it?
Do you mean just the 3 month period? What the period? No, that's a provision in the Act.
Okay.
The Act states that. So that is the provision in the Act that provides for that. Okay. And that is something that you have to keep in the back of your mind. Because if you're dealing with a client and he comes to you and he says, I've just divorced my wife because I'm sick of her, then you immediately have to say, okay, listen, do you want to keep your will as it is or do you want to change it? Because if you die now, she's not going to inherit, but if you die in 6 months' time, then she is going to inherit. Then he'll probably say, no, I'm sick of her, let's change it. Okay. So that is something to keep in the back of your mind. That is one of those provisions that you have to know about, that you're not necessarily going to put on the paper, but it has to be there. You have to know it's there.
So it doesn't go into intestate?
Got it?
So it doesn't go into intestate?
Depending. If she was the only beneficiary, yes, then it would be intestate, because then the will is totally ineffective. If he made no other provision and only said everything goes to the wife, which is now the ex, and it's in that 3 months, then there's nothing you can do, then it's intestate. Okay. If he said, like I said, I leave 50% to her and 50% to the 2 children, then the 50% falls into the residue. Remember, always with a will, if there's an ineffective provision where the beneficiary cannot inherit or is predeceased or whatever, then that part falls into the residue first. And if you've exhausted all the beneficiaries, then you go to intestate. Okay. So first, you always deal with the will if you have a will. Okay.
When it comes to responsibilities of the drafter, you said earlier that if Mrs. X the second, somebody had whispered to her about, look, you know, let's talk about the drafter of this will. Let's say somebody did whisper, would that have solved the problem? How would that have happened?
It would not have solved the problem as far as the division of the estate was concerned. But Mrs. X II could then go to the drafter and said, listen, you have now caused me this damage. You have caused me to lose half of my estate. So come, pay up. Give me. Yeah.
But that's a different court case.
That's totally different. That's a delictual claim. That doesn't fall under the will or under an estate or anything. That is a delictual claim. That she will then say, listen, you've caused me this damage. It's your fault. You were negligent. The same with that first example about the beach house. If those children, the two daughters, heard somewhere, okay, hang on, we can hold the attorney who drafted this will responsible, then they would have claimed the value of that beach house from him. Okay. But that's totally a separate issue.
Would those hold up in court? I mean, no one can force a testator to change a will.
It will hold up, yes, and it has done several times in court. Okay, there has been several court cases where the court said drafter was negligent. That's it. Okay.
But don't you almost, because you signed the will and you read it and it's at your free will that you've actually accepted and you sign it, doesn't that almost like basically then exclude the drafter?
No, it doesn't. Not according to the court if you were negligent. We're going to get to that point as well. Because not advising your client properly, and remember, it's not just a reasonable skill that's required, it's the same skill as required from an attorney and an attorney would have to say to his client, but what happens if she doesn't want to take it? Because there are going to be tax implications. An attorney will have to know that there will be tax implications. And he will have to say to the client, but what happens if she says no? Okay. So that is because then the drafter, in that case the attorney then, is negligent, or the person in the shoes of the attorney drafting that will. Okay.
If I may ask, you're talking about the responsibility of the drafter here. In the event where the drafter drafted a will for the testator who says, I'm leaving my estate to the tenants, and the drafter does not ask, what if your children, why wouldn't you leave to your children and so on and so forth, and the testator dies and now the tenants wants to inherit the estate, which is just an asset from as a property. Do you think perhaps that the children of the testator can take the drafter to court to dispute the will?
If the drafter asked, are you sure you want to leave it to these people? Because you do have children. Are you sure you don't want to leave it to your children? And the testator said, I'm sick and tired of my children. They are a bunch of washouts. I don't want anything to do with them. Or I don't care. They're grown up. They've got their own money. They can go ahead in life. But my tenants are poor people. I'm leaving it to them. Then the drafter has done his duty. He did ask. And then it's clear that was the testator's intention, and there's nothing the children can do. Okay. There will always be witnesses in such a case that will say, but the testator said, this is what I want to do. And testators will talk also. They will tell people, I've made my will and I don't want my children to inherit. I'm going to leave it to my tenants, etc., etc. So then the drafter has done his duty because he wasn't negligent. He asked the question and the testator said no.
But maybe that should go into the will, that I do not want my children to inherit.
It often does. In that Mr. Schnettler's case that I read to you just now, he expressly says, to my children who never had time for me, I don't have time for you. You get nothing.
So would you say the testator must actually say it that I don't want my children to?
It would be safer. It would be safer to state there, I disinherit my children, but you don't have to. You don't have to. Because your intention is clear, and as long as the drafter asked the questions and said, but are you sure this is what you want to do? This is what it means. And explain to the testator that this means your children will not get anything. Then the drafter is covered because the drafter was not negligent. Remember, you have to be negligent to be liable. Okay. Okay, let's quickly look at our standard forms. A few years ago, I asked for the first assignment that students have to draw up a will for themselves. That was the instruction. Now please, when you answer exam questions, or the same with the assignments that you have just done, follow the instructions. If it says draw up a will for yourself, it means you are one person. So of course I got the standard forms that were quickly pulled out of the drawer because it's so much easier just to send this in as an assignment. So the first one says, I so-and-so, identity number so-and-so, married in community of property, revoke all previous wills and declare the following to be our last will. Are you the royal we? So this means this was a standard form joint will that this person used, and of course it cannot work. Because further on it says, the residue goes to the survivor of us. Now this is not a joint will, so where? So we cannot interpret this will. Right. As I said before, these standard forms often start off with, I leave the residue of my estate to so-and-so. You cannot leave the residue if you haven't left the estate to somebody. You first have to leave the estate to someone, and then you leave the residue to someone. So that is another problem with the standard form. Then the absolute gem that I got, I so-and-so, with an ID number starting with 9005, revoke all previous wills, nomination. I nominate my mother, Abigail, so-and-so, ID number again, very, very organized, 6008, etc., etc., to be the sole beneficiary of my estate. Then it goes wrong because it is a standard form. Death of the survivor again. So again, it's not a joint will. There's no question of a death of the survivor. But it gets better. Trust provisions. Should any of the beneficiaries not yet have attained the age of 21 years, I direct. Now, you've just said your mother, who was born in 1960, is your sole beneficiary. Either you had her ID number wrong, or she was 12 years old when you were born. So, please, you cannot use a standard form if it does not work in the situation. Yeah, and then I also had this one. I so-and-so, an energetic young lady residing at. I'm sorry, you're going to be dead. You're not going to be very energetic when we read this. This, you are dead. You are not going to be energetic. So don't make silly statements like that. Okay, so that was just to show you the dangers of using a standard form. Of course, to get the standard wording, it's fine, you can use it, it does help, but do not use a bad one. Use a good one and make sure it works. It actually is applicable in your scenario. And of course, then, the more I gave these workshops, the more I could see people getting really worried. Just as I can see this morning, people are now really worried about this delictual claim. So what happened about 2 years later? I start getting, again, standard forms, and one of the big trust companies, indemnity or disclaimer at the bottom, which reads, by signing this will, it is accepted that so-and-so, as drafter of this will, cannot be held liable for any consequences, etc., etc., the validity of this will, etc., etc. Do you think the court will apply this?
Not sure. The negligence.
Why are they not going to apply this?
Because they're inducing the drafter to indemnify. No?
What is the definition of a will?
Intention of the drafter.
Before you even get to the intention.
To explain the wishes of the testator.
No, what's the definition of a will? It is a unilateral legal act The secret being in the word unilateral. It's not multilateral. You cannot agree with the drafter that he is not going to be liable. The only way that you could possibly do it, if you are really now thinking that you should do it, but that would mean that you don't trust your drafter, would be to do it in the same way as you would exempt your executor from giving security, by stating, I exempt the drafter of this will. But is your testator going to sign that if you put that into the will? I don't think so. And I still have serious doubts whether the court will accept that. Plus, it's in the form of your normal indemnity, which you find everywhere, which does not cover you for gross negligence in any case. So no matter how you try and get out of it, if you are grossly negligent, you are still going to be liable. So if you make a mistake in the formalities, in the formal requirements of the will, you are still going to be liable. Okay, so rather make sure that you don't make mistakes and that you don't open yourself to any sort of claim. And yeah, I haven't seen it again lately, so I assume they know now that it's not going to work.
I know you said there must be two people when the when the testator has to sign the will. But what happens if you don't have a witness or?
Okay, we're getting to that. We're getting to it.
If it's a standard form that doesn't conform with the circumstance of the existing client in front of you, and you try to make it to comply by cancelling and signing, is that acceptable?
As long as the amendments comply with the formalities to start with, and as long as those amendments really work in the client's circumstances. But then you must make sure that those amendments work, plus the formalities there are very important. Because if you don't comply with the formalities, the amendment is not going to be valid. Okay.
Can I ask you, a company that drafts wills like this, or a bank, are they not negligent from the fact that they have a standard form? I mean, there is no standard, we don't buy the same way, we don't have the same circumstances. Is that not an act of negligence in itself?
Well, that would be my attitude, because I hate the standard forms. But yeah, that might be, the courts might say, well, it's a practical thing, because it's just easier if you have a standard form and it's a very simple estate. It's not a very involved estate with lots of properties and lots of different things. So it is possible it can work. And remember, you can buy that standard form at P&A or C&A or one of those shops as well. So then you don't have anybody who you can say drafted it. Then the testator buys it and he changes it like he wants to. So I would agree with you, but the court probably would not agree with us. Okay.
Just last question, are we required to know how to draw up a will in the standard form? What's that standard form? There I go again. Are we required to know how to draw up a will in exam conditions?
Yes, but of course I'm not going to expect you to have the exact correct wording, as long as your provisions make sense. As long as you know, I have to say, okay, I revoke all previous wills, and that's another thing with standard forms that drives me insane, is I revoke all previous wills, testamentary dispositions, codicils, blah, blah, blah. It's a will, that's it. You don't have to have 6 words there to explain you are revoking it. I revoke all previous wills, that's enough. You don't need more than that. And then, of course, if I say to you in exam conditions, draft a will for yourself, this is your properties, this is what you need to do, or if I say to you, okay, the client is sitting in front of you, we're going to do an exercise like that this morning, this is what he has, this is what he wants to do. As long as it makes sense and it's done properly so that it can work practically, that's fine. I don't expect the exact wording from you. Okay. we are now turning to the will itself, where we're going to discuss everything that is necessary. We're first going to look at the prerequisites or the requirements before you actually start looking at drafting the will. Again, exam tips, definitions, as I said, the requirements before you start with the actual drafting, and of course the formalities. You cannot work with wills if you do not know the formalities off by heart. The definitions in succession is so important that it's better to learn it like a parrot. Because what happens is, if you start changing the wording, you start changing the meaning. And if you start changing the meaning, for example, if I ask you what is a condition is an uncertain future event which may or may not take place. Some students will write, it is a certain event which may take place in the future. That's wrong. It's not a certain event. It's an uncertain future event. So by just changing that little word, you're changing the meaning. So rather learn your definitions as they are. And a definition will always get you a mark in the exam. So if I give you a concept and I say to you, okay, what is this? And you give me a definition of the concept, then you will get marks for it. Okay, so your definitions are very important.
You said the requirements before you start drafting a will and the formalities of drafting a will.
And the formalities. We're going to talk about the requirements before you start now. In other words, those are who may make a will. In other words, testamentary capacity, which we will get to just now. Then what type of will or what type of document qualifies as a will? And why is that important? Why must you know that? To know whether it has to comply with the formalities in order to be valid. You have to know whether this piece of paper conforms to the requirements of a will. We will get back to that now. As I said, the formalities have so many little details. I can ask you a question on formalities for 20 marks. There are 20 little points. It's the testator has to sign at the end in the presence of two witnesses present at the same time, etc., 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 etc. So there's a whole list that you have to know. And don't leave a detail out, because if you leave a detail out when you're dealing with the client, you are being negligent. Those details are very, very important. You have to know who may witness a will. And together with that, you have to keep in the back of your mind if the witness is a beneficiary or not. We will also look at that just now.
Just can I ask you a question? What happens if a beneficiary is a witness to a legacy in a will?
We're getting to that. Okay. At the moment, I'm just going through the list of things that you have to know before you even start putting pen to paper. In other words, the things that I've mentioned up to now is before you even get to the content. This is what you have to know, and you have to know I have to comply with this before I even put pen to paper. Okay, we are now going to divide into our groups, and I'm going to give you facts, and you are going to make a will for your clients. So we are going to see whether you know what the formalities are, who may sign, where they must sign, when they must sign, and we are going to see what you do with the content of the will. And then we will, together with that, we will also look at your first assignment, because there was some points relevant to the assignment with regards to formalities as well. You are now the drafter of this will, and you need to decide what to do and how to do it. The facts for drawing up your will. Draw up a will for your client, Mr. Brink, that contains all relevant provisions and that complies with all formalities of the Wills Act 7 of 1953. Mr. Brink is married out of community of property in terms of the Civil Union Act to David Peterson. They were married in January 2007. They adopted 2 children, Krista and Mark, aged 12 and 14, also in 2007. Mr. Brink owns 2 motor vehicles, a Mercedes and a BMW, a house in Pretoria, a game farm in Northwest, other movable assets to the value of 1.2 million rand, and cash to the amount of 400,000 rand. From these assets, he would like to benefit his sister and his mother, and he would like to make provision for his spouse until such time as he remarries. He also wants to leave the house to his spouse on condition that it will go to the children as soon as David remarries. He specifically wants to leave the farm to his sister, to Patricia, on condition that she settles there within 3 years of his death. Since Mr. Brink has 2 minor children, he asks you to make provision for a trust into which the children's shares of the estate can go until they become majors. He also brings along a map of the farm which he wants to attach to the will, as well as some photographs of paintings which he wants to leave to his sister. These paintings are valued at 500,000 rand and form part of the movable assets to the value of 1.2 million rand.
The movable assets.
Is it legal? Okay. I leave to my sister.